Welcome to K&L Gates Working Wise podcast series. My name is Leann Walsh, and I'm a senior associate in the Raleigh office of the firm's Labor, Employment, and Workplace Safety Practice area. In this podcast, I will provide an overview of the United States Department of Labor's new Payroll Audit Independent Determination Program, also known as the PAID program. The PAID program is a 6-month nationwide pilot program of the Wage and Hour Division of the United States Department of Labor, the DOL for short. The goal of the program is to facilitate proactive resolution by employers of potential overtime and minimum wage violations of the Federal Fair Labor Standards Act, also known as the FLSA. These violations would include, for example, off-the-clock work, failures to pay overtime at the proper overtime rate, and misclassification of employees as exempt from overtime. Although employers commonly settle with employees all types of employment-related claims by private settlement agreements, a formal program is necessary to resolve FLSA claims, specifically because the FLSA statute itself requires either DOL or court approval in order for employers to obtain legally effective releases of those claims. The primary objectives of this program, therefore, are threefold. First, to allow employers and employees to resolve FLSA claims expeditiously without litigation. Second, to improve employers' compliance generally with federal overtime and minimum wage laws. And third, to ensure that more employees receive the back wages they are owed faster. There are some important limits regarding who can participate in the pilot program. To start, the employer must be an employer covered by the FLSA. Employees included in the self-audit must not be subject to prevailing wage requirements because these are beyond the scope of the pilot program right now. The employer must not have been found to have violated the FLSA in the last 5 years. And the employer must not be currently a party to any litigation, subject to an investigation, or in receipt of an employee complaint about the compensation practices at issue. Assuming an employer is eligible, the program works in 3 phases: review, evaluation, and settlement. In the review phase, interested employers review the DOL's online compliance assistance materials. These include a 12-step series of videos and informational guides about the FLSA. Employers then conduct self-audits of internal compensation practices and identify potential violations, affected employees, timeframes at issue, and the amount of back wages the employer believes are owed to each employee. With respect to timeframe, the DOL assumes that employers will look back 2 years for violations. This is the FLSA statute of limitations for non-willful violations. Notably, employers must look for violations affecting both current and former employees within this 2-year window. As to the amount of back wages that are owed, the DOL has clarified that it is looking for the full amount of wages an employer believes are owed, but this does not include liquidated damages, interest, or other civil monetary penalties. Employers also, of course, get to avoid litigation expenses and attorney's fees that are often involved in FLSA litigation and DOL investigations. The DOL expects self-audits to generally be completed within 90 days. In the evaluation phase, the employers contact the DOL once the self-audit is complete and provide the following: back wage calculations with supporting evidence and methodology, a concise explanation of the scope of the potential violations for inclusion in a release of liability, a certification that the employer reviewed all of the PAID program's information, terms, and compliance assistance materials, and a certification that the employer meets the PAID eligibility criteria. Acceptance into the program by the DOL is discretionary and on a case-by-case basis. Finally, in the settlement phase, the DOL evaluates all of the information provided by the employer and issues a summary of unpaid wages, along with forms describing settlement terms for each employee. Releases are limited to the potential violations identified in the audit. Employers are then responsible for issuing back wages by the end of the next full pay period after receiving the summary of the unpaid wages. 100% of the back wages due must be paid. The DOL will not distribute the back wages itself. Employers must provide timely proof of payment to the DOL. So when, if ever, should an employer consider applying to participate in the paid program? Here are some thoughts regarding the risks and rewards. Importantly, employers must understand that employees might not accept a paid program settlement. Each employee individually can decide whether to accept or reject the offer. If rejected, the employee retains his or her rights to pursue legal claims against the employer. Employers are prohibited, of course, from retaliating against employees for declining to participate. If an employee files suit regarding the subject of the audit during the audit, the DOL may continue to work with the employer to supervise back wage payments to the other employees. Further, as I mentioned before, paid program settlements may release only the potential violations identified in the audit. State wage and hour law claims, therefore, cannot be included. The DOL has noted in its guidance, however, that these claims can always be settled separately and released. Additional consideration would be necessary for those releases. Also, some employers have expressed concern that if the DOL rejected their request to participate in the program, the DOL might then target them for a federal wage and hour investigation, effectively using the request to participate as a tip to kick off the investigation. The DOL has confirmed that it will not use a request to participate as a basis for a federal investigation unless the DOL has reason to believe that worker health and safety may be at issue. For example, if there were child labor violations. Lastly, it is worth mentioning on April 11, 2018, 11 state attorneys general from New York, Massachusetts, California, Connecticut, Delaware, Illinois, Maryland, Massachusetts, New Jersey, Pennsylvania, Washington State, and Washington, D.C., wrote publicly to the Secretary of Labor to express concerns about the paid program. They denounced it generally as an amnesty program for labor law violators and warned that they would continue to prosecute labor violations regardless of an employer's participation in the paid program. With all that in mind, therefore, in my opinion, the best test case for participation would be an employer operating in a state without its own overtime and/or minimum wage laws, because not all states have them. If this employer was seeking to resolve limited overtime or minimum wage issues, perhaps because the employer wanted to clean up any inadvertent mistakes in order to make itself a more attractive acquisition target, the employer could be a good candidate. It would be an especially good candidate if the employer had good relationships with its employees and felt confident that they would be willing to accept releases in exchange for the paid program payments. I likely would not advise employers in any of the states mentioned previously where the attorney generals have expressly denounced the program to participate at this time. Notably, the paid program records are subject to FOIA requests, just like any other government documents, and I would be concerned that even if the paid program settlement was successful, the employer could have invited significant state scrutiny and possibly a state attorney general investigation or litigation about the matter. After the end of the 6-month pilot period, the DOL will assess whether to continue and possibly expand the program. We'll keep an eye on the program's development, and the K&L Gates Lose team will report further updates as it evolves. I hope you have enjoyed this episode of K&L Gates Working Wise podcast series. More episodes in our series can be found at klgateshub.com, and you can learn more about our labor, employment, and workplace safety practice on our main website at klgates.com. Thank you for joining us.